Thank you, Commissioner.
Good morning, Judge Omwanza Ombati.
Thank you, Commissioner.
Good morning, Judge Njokindongo.
Thank you, my lady.
Good morning, Judge. Anthony Mrima, karibu.
Thank you, my lord.
Good morning, Judge. Fatuma Sichale, karibu sana.
Thank you, my lady.
Good morning, Judge. You are welcome. My name is Olwande Evelyn.
Thank you, Your Honor.
Good morning, Judge. Dorcas Oduor, Senior Counsel and Attorney General.
Thank you, Attorney General.
Thank you. I think we will begin by you, Judge, telling us your county and your ethnicity.
My county is Machakos and I am Kamba.
Very well. We have read your CV and all the money that you supplied us, but we want to hear from your own words the vision you have for yourself and the Court of Appeal. In other words, what is it that you're going to bring to the Court of Appeal?
Thank you, my lady. I'll begin by just giving a summary of myself, and then I'll link that with what the Court of Appeal needs. I am a pioneer judge of the Employment and Labor Relations Court, having been employed in 2012. So I'm about to clock 14 years. I have served in Mombasa and done circuit court in Malindi. I have served in Nairobi twice, and I'm currently serving in the Mount Kenya region, sitting at Nyeri and doing circuit court in Meru. I moved to Mount Kenya in October. Before then, I was presiding judge of the Claims and Labor Relations Division in Nairobi, which is the largest division, carrying about 90% of the caseload. And as presiding judge, I was leading a team of 5 other judges. So we were 6, including myself. And when I came back to Nairobi from Mombasa, I found that Nairobi was running an open system where any case could go to any judge. And because I now became part of the leadership at Nairobi, we sat together with our principal judge, and we made a decision to run the docket system for the simple reason that Nairobi has 12 judges. And if we did not break the work into manageable portions, it was going to be very difficult for us. So we ran a docket system, and we also ran different divisions. And the principal judge assigned me to be the performance champion leader in Nairobi, given the fact that I had served in the Performance Management Steering Committee, which is the precursor of the Administration of Justice and Performance Management Committee. So I was given that dot to run the performance. And for the first time last year, Nairobi became the best performing court in the ELRC. When I was in Mombasa, we also ran a docket system. And when I was there in 2019, again, Mombasa at that time became the best performing court. So I have a record of stamping good performance, excellent performance, wherever I go. I have sat on multiple judge benches with my colleagues. I have also sat in a tribunal that looked at the question of incapacity of a judge on account of mental incapacity. And that was a novel question We did not even have any precedent from the Commonwealth, and we sat with a multidisciplinary team, including psychiatrists, and we were able to deliver. That decision of the tribunal was tested by the Supreme Court, and it was affirmed. My jurisprudence as a judge has also been tested by the Supreme Court in the case of Gishuru versus Package Insurance on this question of indirect discrimination, and I was affirmed by the Supreme Court. I serve as a member of the Judicial Rules Committee, where we look at different sets of rules for different courts and different disciplines. And I'm also a member of the Employment and Labor Relations Court Rules Committee, and we just recently delivered a new set of rules for that court. I was a part of the team that developed the Judicial Code of Conduct and Ethics. I was also part of the team that developed the sexual harassment policy, and we delivered. Now, for the Court of Appeal, the vision that I have is that I will be a judge who is aware that judicial authority is delegated. And therefore, whenever I sit, I will bear in mind that I am a servant of the people of Kenya, and therefore I must work with integrity, and I must also return an account of what I am doing and what I have done.
Thank you very much, Commissioner Mwanza.
Thank you, Judge. You've spoken very eloquently about your view of what the ideal Court of Appeal judge is.
Yes.
As a judge.
Yeah.
I'm more interested about what you think the view of an ideal Court of Appeal judge should be from the perspective of Wanjiku. It's a villager, maybe a widow, who's been thrown out of her house or her home because the husband has died and has come to court to seek justice. Now, you've spoken about what the view is and your achievement. What should be the view of this villager, of this Kenyan of simple means, about what an ideal judge is at the Court of Appeal?
Thank you, Commissioner. I think a person in the village would want to see a judge who understands their social context. A judge who is able to descend to that level of that widow and understand the environment in which they live and understand how they are going to solve their problem. Because at the end of the day, the judgments that we render as judges must solve problems. It does not matter what jurisprudence we churn out. If we are not solving problems at that grassroots level, then we will have failed.
Indeed, because the power, as you say, that is delegated belongs to the people. Now, I want to ask you two questions with respect to a debate that was ongoing some time back, not long ago, in the Court of Appeal about the principle of stare decisis. First, the question is, in your view, is the Court of Appeal bound by the decisions of the Supreme Court?
Yes, they are bound. We are all bound.
And if there is a disagreement about interpretation in the court, strong disagreement?
There cannot be strong disagreement because the Supreme Court is the final court, and the Constitution clearly dictates that judges working in courts below the Supreme Court must follow the decisions of the Supreme Court.
No, there has been that is the theoretical, but practically there were those instances where there is tension. It's not academic. It's a reality that if you find very strong views by the Court of Appeal against the judgments of the Supreme Court, how do you resolve that?
You see, we run a legal system,
Yes.
and a legal system must be coherent. The legal system does not belong to us as judges. You know, as Linnet, I may have strong views, but when I sit as a judge, I must fit within the legal system, because if we do not do that, then we will cause chaos. And that is why there is a final court on these issues.
Okay.
And because the Supreme Court can depart from its decisions, I believe that if the Supreme Court is convinced that they may have got it wrong, they will be big enough to now redirect the rest of us and say, on this question, we have heard what the public is saying, we think we now need to change course. But it cannot be that either the High Court or even the ELRC or the Court of Appeal can decide to change course, because then they cause confusion within the legal system.
Thank you. Now, there are two decisions that have been delivered by the Supreme Court. Case of Republic versus Joshua Mwangi. I don't know whether you've read it. It's on a sentence with respect to the Sexual Offences Act. And also the case of Republic versus Julius Kitsau. The question that I want to pose is whether the Court of Appeal can assume original constitutional jurisdiction to determine whether a sentence is unconstitutional. That's number one. And number two, I'd wish to ask whether the harshness of a sentence is a matter of fact. And if indeed it is, can the Court of Appeal examine that?
With regard to the sexual offenses, there are minimum sentences that are prescribed by law. And I have seen the guidance from the Supreme Court to the effect that the courts cannot tinker with the sentences that are prescribed by statute, because then they will be overreaching and actually interfering with the legislative power, which does not belong to the courts. That is what I have read from the Supreme Court. The harshness of a sentence, I don't think is a matter of fact, because if it is prescribed by law that there is a minimum sentence, and the judge or the magistrate applies their mind and metes out the minimum sentence, then it cannot be a matter of fact. It's a matter of law.
Okay. All right. And the other question that I asked that I have not heard your views is whether the Court of Appeal has original jurisdiction to determine the constitutionality of a sentence.
No, I don't think so, because these matters begin in the High Court and escalate all the way through the Court of Appeal to the Supreme Court.
All right. Thank you. Thank you, Chief Justice.
Thank you so much, CJ, and once again, Judge, welcome. Now, I want us to briefly look at issues relating to children. And I understand in your court, you deal with those issues in many aspects, maybe on child labor and many other areas. Now, practically, we just want to have an insight on how it is. Practically, what challenges do you encounter as a judge when dealing with matters relating to children?
The difficulties one would encounter in dealing with the matters relating to children is that, first of all, a child is one of the most vulnerable members of the society. They cannot speak for themselves. And that is why the law states that in any case touching on children, the best interests of the child must be paramount. And therefore, as a judge, whether it is a matter of child labor or any other branch of law, really the judge must agonize about what is the best interest of this child. Forget the parents, forget the adults, what really is best for this child. And it may not always be possible that the best interest of the child is agreeable even to the parents or to people who are very close to this child. Yes.
Okay, thank you. There has been an uproar of late in respect of a decision which was rendered by the Supreme Court, which was around the issue of children, best interests, and all that. Are you aware of that decision? And maybe if you are aware, what was the issue in respect of that?
Yes, I'm aware of the Supreme Court decision on the issue of a child born of a Muslim man out of wedlock. And the question was, because Islamic law would say that a child born out of wedlock cannot inherit from the deceased father. And the question that was before the Supreme Court was whether that law can survive constitutional scrutiny. And the Supreme Court said that that section of the law that allows application of Islamic law must be read very narrowly, so that at the end of the day, you cannot derogate the rights of a child to inherit depending on the circumstances in which they were born, because really they had no part in it. That is my understanding of that decision.
Okay, thank you. I think I'll hold it at that. Thank you so much, Judge. I wish you the very best. And
Thank you.
Thank you.
Chair?
Yes, Attorney General. Thank you. From where I sit, I think public interest litigation should serve the wider purpose for the public. And therefore, when a matter is fashioned as a public interest case, the judge should ask the question, the remedies that are being sought, do they transcend the interests of the parties who may be presenting these cases? Or is it just that there are people who want to couch a case like it is a public interest case to achieve personal interest? So I think the question should be, do these remedies benefit the wider public, or do they benefit an individual? And then, of course, the judge should also guard against people just coming to court to punish others. They want to get stay so that somebody else doesn't get a job, for example. So I think if a judge asks those questions and we keep consistently asking those questions, then we can guard against abuse of public interest litigation.
At what point do you think judges should ask those questions?
I think it will depend on the case, but ideally it should come in the judgment, so that after you've heard the parties, you can finally say, okay, I'm dismissing this petition, but I need also to say that really this was not a public interest case. And if we pronounce ourselves over time, I think we should be able to communicate where we are coming from.
Okay. While courts traditionally follow the event, public interest litigation has developed a distinct cause of suit jurisprudence. What factors, in your view, should justify an award of costs against a petitioner who invokes public interest, and how should appellate courts calibrate such awards to avoid chilling legitimate constitutional claims?
I think if at the end the judge determines that this petition should not have come fashioned as a public interest case, then costs can be awarded. There can also be situations where the petition is struck out in limine, because, for example, if somebody is just coming to court to avoid, say, limitation, and they fashion a petition, then it can be struck out in limine, and costs can be awarded in that regard.
Can the Attorney General be awarded costs?
In exceptional cases, yes, where there is blatant abuse of that of the court process.
Are you aware of any case?
I'm not aware of any case.
Thank you.
Thank you, Chair. Judge,
Yes.
as a court, we struggle with mandatory sentences. And of course, a criticism of this is that it interferes with the principle of separation of powers, in that the legislature cannot arrogate itself the power to determine what constitutes appropriate sentences in specific cases. What is your view on this?
Ideally, judicial officers and judges should be given discretion to sentence. But
Why?
because they have the tools to gauge, what sentence to met in certain offenses.
What are these tools?
The first one is that they have the opportunity to look at the circumstances of the case during trial or even on appeal as they review the record. But if Parliament, in its wisdom, has established a minimum sentence for certain offenses, say the sexual offenses, and of course we know that there is a history why that particular legislation was passed. It was because the public, through the elected leaders, felt that some of the sentences that were being meted out were too low, given the severity of the crimes that had been committed. And so in such a case where Parliament has decided to enact a minimum sentence, I don't think the courts have any leeway to change or to interfere with those minimum sentences. It would have to be another sort of intervention where...
So you do not think it is parliamentary overreach?
To set minimum sentences?
Or legislative overreach when they set minimum sentences? Because as you rightly point out, circumstances and facts of a case are always diverse. Yeah. So
Yes.
you don't think it is legislative overreach?
I don't think so. I don't think so, because there is a history as to why those particular sentences were put.
You're just thinking about the Sexual Offences Act. I'll give you a scenario, and
Yeah.
this was a real situation.
Yes.
When I worked as a judge in Malindi, one of the appeals that came before us involved a young man who was in company of other young boys, and there was this young lady who had been sent to the butchery by her grandmother to buy her piece of meat. On her way back, she was wrapped up by these boys, and the boys were armed in quotes with sticks, and they took the half kilo of meat. And the young person who was actually subsequently arraigned was charged with robbery under the Penal Code. And the sentence for a robbery under Section 296(2), I'm sure you know, is what?
Death. Stroke 2?
Yes, stroke 2.
Yeah, robbery with violence.
So given those circumstances, compare that with a situation where there is a violent robbery that even results in the death of the victim. Would you still say then, in a situation like that there is no legislative overreach when the legislature, the legislative arm of government, provides mandatory sentences?
I hear you, my lady, but I would say that the role of the judicial officer or the judge in a case where there's a mandatory sentence cannot be to substitute what has been given by Parliament. And I would say that it cannot be said to be overreached by Parliament for them to enact minimum sentences.
So if we sentence that young man who stole half a kg of meat and sentence him to life imprisonment, do you think there is justice there?
If the sentence is as prescribed by law, I would say there is justice there.
I don't know what your sense of justice is, Judge. Somebody has just stolen half a kilo of meat. Another one has committed a robbery and that has resulted in the death of the victim. And you say it is just to sentence either of the two to life imprisonment?
Yes, because you see, if we begin to say that we can tinker with the minimum sentence, then I think we would cause more injustice, my lady. That's really what I think.
Well, I hear what you're saying, but just again, like of course, as I said, we struggle with this issue of mandatory sentences. Are you aware of an attempt by the Court of Appeal to get out of this quagmire by saying that, we are not, this is legislative overreach and we are not bound by mandatory sentences?
Yes, I am aware of that attempt.
In which matter?
I can't remember the case, but I have seen that decision.
This is actually the matter that Commissioner Mwanza referred you to, Joshua Gichuki Mwangi versus the Republic. Is that the one that you also have in mind? And in this one, the court says, circumstances and facts of cases are as diverse as the various cases, and merely charging them under a particular provision of laws does not homogenize them and justify a general sentence. You are hearing what the Court of Appeal is saying?
Yes, I'm hearing.
Do you think then that would be a neater way of saying we are not going to be bound by mandatory sentences?
My lady, as I said earlier, we are in a legal system. Because I'm also aware that the Supreme Court has said something different. So if the Supreme Court, if we are to get out of that difficulty, we really must do it through the legal system. Because if you allow the 200 of us to exercise discretion and say, here you can tinker with the minimum sentence and here you cannot, then I think we will have more chaos and we will have more injustice.
You're actually right, because this matter subsequently went to the Supreme Court, and the Supreme Court spoke the way you are speaking, that we cannot tinker. But I think the injustice is with us, given the case that I've given you.
Yes.
Thank you.
How are you again, Judge?
Thank you, my lady.
I was looking at your curriculum vitae, and I see that you used to sit on the task force on the review of laws relating to persons with disabilities.
Yes.
Looking at the Constitution now, the Constitution 2010, have some of the issues that you raised in the task force been addressed, and which ones are these?
Yes, I would say that many of the issues that we were dealing with have actually been addressed because we were looking at the principle of accommodation, for example. You know, a person with a disability at the workplace, let me give that example, requires certain facilities that the rest of us may not need. So that principle of accommodation has been taken care of by the Constitution, and actually the law has since been amended several times to just make sure that persons with disabilities have equal opportunity to thrive in the society.
Is there anything left outstanding in the task force that you can see, even with the Constitution of Kenya, has not yet been done for persons with disabilities? Or do you feel that that currently the implementation of those rights is progressing well?
Yes, I would say that we have everything. It is now for us as the judiciary to breathe life, because again, the law cannot write everything. But I think the Constitution has given us enough to work with. And because we also apply the international instruments, which are fairly rich, then I would say that we have enough. I would not say that the law is lacking. If we were to treat persons with disabilities badly, then it is us as judiciary who will have failed.
Thank you very much. You also have told us that you were involved in the drafting of the sexual harassment policy for the judiciary. Why is there need for such a policy, and in fact, what is it?
Actually, the correct title should be anti-sexual harassment policy, because the idea is to discourage or to make it expensive, for people to engage in sexual harassment. So the policy needs first of all to define what is outlawed, and then to give room for reporting, to give a structure for reporting. And it is the responsibility of every employer to make sure that that policy is in place. And I have not seen the judiciary anti-sexual harassment policy tested in our courts. I've not seen it tested in our courts. But we have certainly seen other organizations' policies being tested in our courts, and there is rich jurisprudence on that.
Okay, let me leave it at that. Thank you very much.
Oh, you've already done. Okay, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, Judge.
Good afternoon, Commissioner.
I'm the person who is known for offering water. So if you need water, you can take the water.
I had drank some outside.
Great.
Thank you.
Okay. We've gone through your sample writings. You submitted 5. One is on constructive decisions on constructive dismissal, industry action within the right to industrial action within the medical sector, freedom of religion, and unlawful termination. So your writings show strong command of employment and constitutional law across public and private spheres. You demonstrate the ability to identify and frame issues precisely. You're able to apply precedents well and balance competing constitutional and statutory interest without absolutism. Your tone is measured, coherent, and restrained. And we see you have contributed into the development of jurisprudence around the area of employment and labor. So we thank you for that.
Thank you.
So among the sample writings you submitted was on religious freedom. with regards to employees of the SDA church, and you did hold that there was a violation when their employer failed to allow them to worship on Saturdays.
Yes.
If the scenario was different, where the employees were members of the Kenya Defence Forces, how would you balance the rights of officers from the Kenya Defence Forces with that of national security that requires KDF officers to practice, offer their services, including on days that they're expected to pray or they're not expected to work? How would you balance the two rights?
Thank you. Actually, even in that decision that you have mentioned, I made it clear that freedom of worship is not absolute. So there are days that even for, SDA adherents, they'll be required to work on Saturday. But what I said is that a policy that is rigid, that says our hours of work are Monday to Saturday is unreasonable. So in the same vein, if I were to do that case for, defense officers, I would say that if they are required to work every Saturday throughout the year, they never have time to pray, then that is unreasonable. But I would also say that I would expect flexibility on both sides, so that the officers are flexible enough to negotiate with their colleagues to hold their fort. But the bottom line is that, you can't say an employee will never worship for the rest of their lives. That would be my view.
Okay, so within the context of national security?
Within the context of national security, of course,
operational preparedness, because at times you have KDF officers expected to even exercise,
yes, go
on certain assignments.
Yes.
So how would you balance the two?
Okay, of course I know that for SDA they have the hours of worship, but I would expect if you are deployed as a security officer, you should be flexible enough so that even within the camp where you are based, you can actually worship. So that you're not saying it is from 5 to 5. You just take a few hours to pray. That's the way I would look at it. But you can't say you leave your camp on Friday evening and come back on Sunday morning. I would not expect that to be reasonable.
Okay.
Yes.
So there is none that would be superior to the other? Individual religious interest?
Yes. Yeah. But there will be none that is superior to the other. And even there will be times when you are told, like, for this period, you cannot worship because we are at war, for example. So I think it really depends on the job that you are doing. If you look at that case, these were bankers. So I thought that with technology, there should have been a flexibility for them to worship and also work.
Okay.
Yes.
And lastly, what are some of the factors a court is expected to consider before ordering reinstatement of an employee?
The primary one is the practicability of that remedy. Of course, the law says that if you've been out for more than 3 years, you cannot be reinstated. That is standard. But over and above that, for example, if you work for a small organization that has like 10 people and you've disagreed with your manager, for the court to send you back, actually they'll be sending you to the gallows, because whoever is looking for you will find you. So even for the employee, it is not always the best remedy. If you are in a large organization like government, government institutions where you can be taken to another station, then that can work. And then, of course, you also consider that position that you were holding, has it been given to somebody else? Because you don't want to enforce the right of an employee who has been terminated and in the process violate the rights of another employee.
Okay. You state that the law provides that you cannot be reinstated after being out of service for 3 years.
Yes.
If that is according to you.
Yes.
So recently, the Supreme Court, in the case of Kamande versus the Judicial Service Commission, reinstated a person who was out of office for a period of 5 years, over a period of 5 years. Where does that place?
Okay. The law gives the option of re-engagement in such a scenario where, you see, reinstatement is that you come back to the exact
I would
position.
have expected. Well, let me finish my question first.
Yes.
When it comes to the place of the law,
Yes.
and what the court has decided, where would you place the decision of the Supreme Court and what the law says?
The way I understood that decision is that the Supreme Court ordered re-engagement. I did not understand it to be reinstatement.
Okay.
Yes.
Thank you.
Yes.
Thank you. Thank you, Chair.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Your Honor.
It's been a long morning spilling over to afternoon.
Yes.
Yes, I'm looking at your performance results from this POP. You are alone at Nyeri,
Yes.
so there's no comparison.
And I have just reported in October.
Oh, really? Okay. So the only thing we can compare you to is the performance targets.
Yes.
And so I just want to hear from you as a judge of the ELRC.
Yes.
What should be your targets in terms of judgment annually?
In terms of merit productivity,
Yes, merit productivity.
it's just
Merit resolution, sorry, not productivity, but merit resolution.
just of, is it 115, I think?
How many judgments are you supposed to write in a month?
20.
Are you sure about
Is
that?
it
That's
20?
mine.
Is it 20?
That's mine, Judge. Yours is 10.
Yes, 10.
Yours is 10.
10.
So if we take away 1 month when you're on leave, that should be 110,
Yes.
not 15. Yes. So I'm looking at your performance returns. You seem to be doing okay, especially the previous years. There was a dip in 24, 25. Maybe you can tell us if there was. At least is the time you were transferred then to Nyeri. Is that so?
No. I was transferred to Nyeri in October
October of 25.
or 2025.
Okay. Because what I have here for your judgments, your merit resolution is 115, so that is fine, because judgments is just the pure judgments, so that is okay. So essentially, Judge, you are doing well even the half year. If you are to look at the half year report, I see you already have over 50 judgments for this half year, for the financial year 25-26, so I think you are doing well. So maybe we can discuss something else.
Thank you.
The term judicial craft. What is your understanding of judicial craft and what are its components?
Judicial crafts are the abilities and skills that a judge or a judicial officer brings to the work that they do. That's the way I understand it.
Yes, that is correct. What are the key components? You can give me 3.
The key components would be the ability to understand the matter before them and to apply the law to the facts. And ability to also apply the Constitution in appropriate cases.
So that's essentially the ability to understand and apply the law and interpret the law.
Yes.
Yes, that's one component. Another one?
The others escape me.
Okay. Maybe you will look at that later. Is it important for the JSC in recruiting judges, like in the exercise we are currently undertaking? Is there a sense or the abilities of a judge in terms of judicial craft? Is it important for JSC to consider that?
Yes, I think it is important to consider that, because that's really what we do on a daily basis. I mean, you get all sorts of cases, and, for example, the ability to apply the law in appropriate cases is really key, for any judge or judicial officer. Yes.
So would you say that a judge, or a candidate for that matter, for judgeship who has not been a judge will not have judicial craft, or will not possess judicial craft, in your view? Is it limited to only people who've worked as judges?
Well, I wouldn't say so, because, of course, the Constitution recognizes other experiences that people can bring. But I would say that somebody who has gone through the system, from the magistracy all the way up, obviously has more experience, because they have handled more cases. But that does not necessarily mean that they are better. It just means that they have more experience, and therefore the learning curve will be not as short as somebody who comes from outside. That's what I'm saying.
Okay. Thank you, and I wish you well, Judge.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
How would your colleagues describe your professional integrity?
I think they would say that I am consistent in terms of my integrity, because I believe that my integrity has been tested over the close to 14 years that I have worked in the judiciary.
Okay. Some stakeholders have commended you on your integrity. However, there are some who hold contrary views, and they have cited some instances where you occasionally demand your drivers to be paid per diems when you have sent them to run your personal errands. And some said that while you are in Mombasa, some staff members perceived you as being discriminatory. And some cited some instances where you clearly stated that you did not want to work with staff from Coast. What do you have to say about that?
Okay, I don't remember demanding my driver to be paid per diem for running errands, my personal errands. So first of all, my driver does not run my personal errands. Now, the Mombasa incident, when I went to Mombasa, I found staff who had worked in that station for very many years. And there were challenges in that station. But I did not say that I did not want to work with staff from the Coast region. I just said it is good practice for the transfer policy to be observed. So that is the only incident that I recall about Mombasa. But I did not say that I did not want to work with people from Coast region.
Okay. No. Fair enough. Now, should the judge be involved in the budgeting process?
Yes, I believe so, because the judge is involved in the core business of the judiciary, and it is in that budgeting process where what is required for the court can be prioritized and put on the table. Yes.
So in the event that the budget for the Court of Appeal is cut by 20%, what innovative non-financial resources would you leverage on to reduce the case backlog without necessarily having the financial or the monetary resources?
I would recommend use of the technology that we have already rolled out, because the judiciary has a very effective ICT facilities that we can use to hear cases. And of course, appeals, you do not need witnesses, so you can hear them from wherever. So I do not think that the reduction of budget should affect disposal of appeals necessarily.
Thank you, Judge. I wish you all the best.
Thank you.
Good afternoon, Judge.
Good afternoon, Commissioner.
Please tell us, how do you handle negative feedback and criticism?
I introspect and ask myself, this criticism, of course, after I have breathed in and out, because there are times when the criticism is not fair, but then I go back and retrospect and ask myself, could I have caused this person to say what they did? And there are times when we have blind spots. I mean, we all have blind spots. So I do a lot of introspection.
Okay. You're in the Employment and Labor Relations Court.
Yes.
What would you say are some of the emerging trends in the management of people in the workplace?
We have challenges of working remotely, for example, in terms of when people are working remotely, how do you control them and how do you manage them? Then there is the challenge of what I would call issues of mental health. They have really begun to manifest themselves, and the stick is no longer working. And therefore, I would say that just soft skills to manage staff who may be struggling. So those are the ones that I say.
Okay, you've mentioned the issue of mental wellness.
Mm-hmm.
How do you decompress and ensure that your mental health is well preserved at all times?
I work hard and I play hard.
Expound.
That as I work, once I have worked, put in a day's work or a week's work, I find activities that allow me to debrief. I walk, I exercise. Yeah.
Okay. I'm sure you have a team of the younger generation working under you.
Yes.
What are the practical initiatives you've put in place to ensure that they are motivated and engaged at work?
Okay. What I find, the young generation are very agile in terms of technology. So I've also tried to catch up, because they communicate through technology, and they also have an opinion about things. So I listen more and I engage them more, and I find actually sometimes they give solutions that are quite useful.
Okay.
Yes.
All right. Thank you, and I wish you well, Judge.
Thank you.
Thank you, CJ.
Good morning again, Judge.
Good morning, Commissioner.
Right, now, although already it's afternoon, now, do you sometimes participate in community service other than your rigorous legal responsibilities?
Yes, I do.
Mm-hmm.
I am very involved in my church, for example.
Yes.
And I do a lot of activities in terms of supporting churches and supporting ministry.
Yes.
I also assist at the village level in assisting families who may be in difficulty. Yeah, so that's what I would say I do.
Why do you believe community service is important in public institutions?
It is important because it is a way of us giving back to the community, from whom we get the resources that we work with.
Yes, and how do you ensure community service initiatives are inclusive and responsive to local needs?
Through engagement of the community, so that you don't just bombard people with projects. You don't sit in Nairobi and think that this is what the community needs. So you'd have to discuss with them and find out what are their real needs, because there is what we think they need, but they are the real needs that they have.
Okay, thank you. Thank you, CJ.
Thank you. Thank you. Judge, I think we have almost come to the close of this interview. But before that, I would like you to clarify one issue which was raised about the way you conduct proceedings, especially where the parties had entered into consent, agreeing that when undertaking the elections, one position would not be filled. But you overlooked that consent and allowed the elections to go on, despite, there having been a consent by the parties. So what would you say about that complaint?
Yes, I received that complaint, and the facts of that matter are this, my lady. There were 3 cases. One was filed in Nakuru, and it was transferred to me by my colleague in Nakuru. The other one was filed in Nairobi, and it was transferred to me by my colleague in Nairobi. Then the third one, it was presented to one of my colleagues, and if you look at the consent that was drafted by the parties, it actually contained judicial pronouncements. For example, it said, it did not just say we are withdrawing the case and, so the parties went ahead and made judicial pronouncements saying the complainant can run for any office in the union. Now, when I was now presented with a similar case, questioning the capacity of the complainant to run, then I asked myself, okay, there is this consent which was adopted by my colleague, because it is not my colleague who wrote down the consent. It was actually the parties who wrote down, and they made, they made judicial pronouncements to the extent that they were saying that the complainant is not barred by any law to run for elections. Mm-hmm. And therefore, I now had another party who brought the same question to me. And I asked myself, as a custodian of justice, what am I going to do with this party who is complaining about the capacity of the complainant to run for office? So what I did, and if you check, that was 2016, we were still running open court. And so I summoned the advocates for the parties. And at that time, the complainant was being represented by the same council as the union. And we had a conversation. So I called the petitioners' council. I summoned the petitioners' council, and I summoned the complainant's council. And the complainant had the same advocate as the union. And this was the eve of the elections. So I asked them, you are officers of the court. There is this question whether a member of parliament can run for union office. It's a substantive issue. So if I do not hear it, what will this other party do? And again, I was thinking that this is a union that has many teachers as members. So the parties that were before me were not the only parties who had an interest in the matter. And counsel for the complainant agreed that, Judge, let us vary the earlier consent so that you can hear this matter on merit and so that you do not stop the entire elections. Because the other option that I had was to stop the elections on the eve. And I thought that would be very disruptive. And because it was only this one position that had an issue, we agreed that let us delay it so that you can determine this question. So it was not ex parte, it was not suo motu, because counsel for the complainant was in court. And I have provided the handwritten notes that show that counsel for the complainant was actually in court, and he agreed to that. Yes.
I think I'll take that answer because your court is also inquisitorial. So how do you think we can reduce, because I think it is palpable that there is tension between the various arms of government because of the role of the judiciary in balancing and checking. How do you think we can reduce the tension between the various arms of the government?
I think if each arm does its role according to the Constitution and the law, there should be a reduction in tension. For the judiciary, because the judiciary is usually the last port of call, I think we should, as far as possible, allow the other arms of government to do their work and do their processes to the end, because we also know that we can undo what they have done. Because I think the tension comes where we interject in the middle before they finish their processes. For example, if it is a legislative process, you know, I would say that it should, as far as possible, be allowed to proceed. Because at the end of the day, that statute will be subject to scrutiny by the courts.
Thank you. Thank you very much, Judge. I think this brings us to the end of a very robust engagement with you this morning. And before we release you, we always give a candidate the floor to also engage us. So the floor is yours now.
Thank you, my lady. First of all, thank you for the opportunity that I've been given by this commission to appear before you. I just have a comment about the performance appraisal system that we run. We do very well in measurement, but I feel that we could perhaps put a bit more emphasis on the management, the performance management of it. And by this I mean that the supervisors, whether it is heads of court or whether it is presiding judges, could be given a bit of leeway to work with the judicial officers and the judges that they work with, so that issues of performance can be managed at that level. And even at the Chief Justice's level, there ought to be some sort of leeway for the Chief Justice to work with us as judges and correct us. Because, you know, when you are at the workplace, many things can happen. And I would say that some of the things that trouble us could actually be addressed if we put a bit more emphasis on the management aspect of performance. That is my comment.
Yeah, very good comment. That judges should support each other if you are presiding judge.
Yes.
Isn't that the role of the presiding judge? When you are in a station, Isn't that the leadership role of the presiding judge or the principal judge or the head of the station?
You know, I would say that we need a formalized way of doing that, because what is the difference then between that support and judicial supervision? Because you see, a judge will say, I am independent. So you cannot even, you have no room to ask me questions. But if we formalize it and we have policy guidance, then we normalize it, and you'll find that, you know, these things that trouble us, some of them will go away. That's my view, Chief Justice.
I agree. Yeah. So we'll be engaging you on that. Yeah, to see how we can help the presiding judges do the work of mentorship and especially on performance. Yeah. Anything else?
No, thank you.
Thank you very much for coming. On behalf of the commissioners, we wish you all the best.
Thank you.
And we'll get in touch with you when we complete the process. Meanwhile, keep up the good work.
Thank you.
Yes, and since you are handing a station, you're managing a group of people, do your best in leadership.
Thank you.
Yes.
Thank you, my lady.